Good morning. This is Tanisha Williams with the Florida Sheriff's Association, and on behalf of our President, Sheriff Mark Hunter, and Executive Director Steve Casey, I'd like to welcome you to our 2018 Ethics Law Training webinar. Florida law provides that constitutional officers must complete 4 hours of ethics training each year before December 31st, and attest on financial disclosures that the training has been completed. During the month of October, the Florida Sheriff's Association will be hosting a series of webinars that will meet the required ethics training for sheriffs. A sheriff can obtain the required 4-hour ethics training if he or she participates in the 4 live 1-hour webinars, or if he or she watches the recorded version of the webinars. As stated in the webinar notification, at the end of the training series, certificates of completion will be sent to those registered for each live webinar. If you watch the recorded version of the webinar, you will not receive a certificate. Instead, please have your training coordinator document your participation to include in your training file. Before we begin with our training today, I'd like to remind you of a few housekeeping tips. Please mute your phones during the presentation. Please do not put the call on hold at any time. And at the end of the presentation, we will open up the line for questions. Joining us again on today to discuss public records sunshine law is Mr. Wayne Evans. Wayne is a shareholder at the firm Allen Norton & Blue and serves as the General Counsel for the Florida Sheriff's Association. Wayne specializes in labor and employment practices representing management. Welcome back, Wayne.
Thank you, Tanisha. Good morning, everybody. For those of you all that are recovering from Hurricane Michael, our best wishes are with you all. Tallahassee's mostly got power back, but I know that's not the case for many of the counties. So we know y'all are struggling, and thoughts and prayers with y'all. Okay, the last couple of weeks we talked about ethics, and this week we're going to speak to the Sunshine Law and an introduction into the Public Records Law. Next week is all about the Public Records Law exclusively. So let me preface my remarks by explaining that the Sunshine Law is similar in many respects to the Public Records Law because it's all about transparency. The Sunshine Law is sometimes confused with the Public Records Law, but it's really a meetings law, an open meetings law, whereas the Public Records Law is all about the records. So for us to really understand the two, we're going to cover Sunshine Law first, and as we're going to see, the Sunshine Law really doesn't have that much applicability to a sheriff's office, certainly not to the extent that the Public Records Law does, but there are some instances in which the Sunshine Law applies and you need to know about it. So at the outset, as in the case of the Public Records Law, we note that the foundation of the Sunshine Law is statutory. It's also constitutional. Article 1, Section 24B of the Florida Constitution provides for a constitutional right of access to meetings of collegial public bodies. That's codified in the statute, Section 286.011 Florida statutes, which provides a right of access to public boards, commissions that meet. And there are 3 requirements, as noted, that the meetings have got to be open to the public, there's got to be reasonable notice, and that minutes of the meetings need to be taken and promptly recorded. All right, so with that, as you can see, if this provides a right of access to a public board or a commission because you run your agency and not a board, then the Public Records Law, again, is going to be more applicable to your agency than the Sunshine Law because you're not typically involved in meetings with regard to the running of your agency, at least where you've delegated some authority to a panel or a board within your agency to make decisions for you. As the sheriff, because you have independent constitutional authority and you reserve that authority with regard to the decisions in your agency to yourself, typically, if there are meetings within the sheriff's office, for example, you've got boards that meet for the promotional process, that are interviewing applicants. You may have pre-disciplinary boards. Maybe there's 3 of them, a captain, a couple of lieutenants that are meeting to make recommendations. because you've got the final say with respect to the discipline, you've got the final say with regard to promotions, you've got the final say with regard to hirings. Those meetings aren't governed by the Sunshine Law because you haven't delegated the authority to that board to make the decisions for you. So in most cases, the Sunshine Law is not going to be applicable to the Sheriff's Office with a few notable exceptions. And we can speak to pre-disciplinary conference. And as I said before, if you don't delegate the authority to a pre-disciplinary board to make the final decision on discipline, that's a recommendation, and that's not covered by the Sunshine Law. If for some reason, maybe with regard to certain discipline, perhaps, minor suspensions, you give the board the ultimate say, then that would be required to be in the Sunshine Law, duly noticed and, recorded. So you want to keep that in mind. I think in virtually every sheriff's office that I know of, if there's a pre-disciplinary conference, more often than not, you have a captain or a major that's handling it, and because it's one person, you don't have a board or commission, so the Sunshine Law wouldn't apply. But if your policy provides for 2 or 3, that panel that's making the recommendation to you following the pre-disciplinary conference isn't covered by the Sunshine Law because, again, it's a recommendation and you haven't delegated final authority to them. And that's apparent from this Jordan versus Jenny case, where Sunshine Law was not applicable to this Professional Standards Committee because the Inspector General had final authority and didn't deliberate with the committee. That would be true for you as well. Okay, so for those of y'all that have a civil service law or a career service law, and it provides for appeals of certain discipline, such as suspensions, demotions, terminations, for a board, either a standing board, like a civil service board, like they have in Brevard County, for example, or ad hoc boards. That's true for most of these career service laws. Sheriff picks 2, employee picks 2, the 4 of them pick the 5th. Those meetings of the board to hear the appeals of discipline are subject to the Sunshine Law. I think most of y'all are aware of that. That's probably not a surprise. So to the extent that the Sunshine Law applies, then when the board meets to hear the appeal of the discipline, that's under the Sunshine. It's, needs to be recorded, and also reasonable notice needs to be given. It's a good idea to post notice in your lobby, put it on the website as well, and that would take care of the notice requirements. Years and years ago, I learned the hard way about the Sunshine Law with regard to the deliberations of the board, and a board chairman, after we concluded the evidentiary part of it, wanted to avoid having the court reporter take down everything that everybody was saying. He thought that the board's process would flow better if they still met in the public, but they were able to, bring the chairs together and then have a more free-flowing discussion that wasn't subject to one member speaking, finishing, letting somebody else do it, all of that, which would be captured by the court reporter. And that's exactly what transpired, so that the court reporter didn't capture the deliberations. Once this was done, it was challenged as a Sunshine Law violation, and circuit court agreed that the deliberations had to be done not only in the public as they were, but also needed to be recorded. So keep that in mind when you have a board, that the deliberations also need to be in the Sunshine and they need to be recorded. Also, something else to keep in mind with regard to your career service boards and your civil service boards, if you have an ad hoc board, the one where you pick 2 and the employee picks 2 and the 4 of them meet to select the 5th, that meeting of the 4 to select the 5th, that needs to be in the Sunshine Law as well. So you need to have a notice posted in your lobby and on the website of the meeting of the 4 to pick the 5th member. That's how the notice should read. And that should be treated as being in the Sunshine Law, just like the evidentiary hearing of the board with regard to the appeals. And this is recent, and this is as a result of the Safe Schools Act. There was a question posed to the Attorney General about if there was a meeting among like members of, say, a city commission and school board, and they were to discuss the school security system, would that part of the meeting be exempt from the Sunshine Law? And the answer to that was yes. The rest of the meeting might be an open meeting, but to the extent that they were discussing school security measures, that could be closed to the public. Okay, so that's really all I need to say about the Sunshine Law. Again, as a general rule, the Sunshine Law is not going to be applicable to a sheriff with regard to those exceptions that I've noted. And we're going to spend most of our time talking about the Public Records Law. And as in the case of the Sunshine Law, it's grounded in the Florida Constitution as well as Florida statutes. So it's Article 1, Section 24, and this is Paragraph A of the Florida Constitution, providing that every person has the right to inspect a copy of public record made or received in connection with the official business of any public body, officer, or employer of the state, persons acting on their behalf, except with respect to records exempted pursuant to this section or specifically made confidential. All right, so with that, something that we always want to keep in mind. To the extent that the Public Records Law provides a right of access to records that are made or received in connection with the official business of the agency to perpetuate, communicate, formalize knowledge, if there are exemptions that would allow you to withhold a public record, that's got to be statutory as well. In other words, we can't assume exemptions. We can't just presume that a record may not be subject to disclosure because it sounds like something that might be exempt or confidential. A couple of really good examples. There's a prevailing view that juvenile records are confidential. There's a prevailing view that medical records are confidential. Well, you know, we know that's not necessarily the case. With respect to juvenile records, if you look for the statutes that will provide for the confidentiality of juvenile records, then that's going to be with respect to juveniles that are not charged with a felony offense or transferred to adult court. So simply because some record, you know, like an offense report, an incident report of a deputy happens to identify a juvenile, or you have a video like of a traffic stop that has the kids in the back seat and, you know, clearly identifies the kids. There's nothing that I know of that would provide for an exemption for the identity of those kids. Same thing, you know, with regard to medical. There are certainly laws that are applicable with regard to medical records, and, you know, HIPAA applies, you know, to those records with respect to your employees, their medical records. It would apply with regard to inmate medical records, but HIPAA doesn't just generally apply to any other medical record, you know. So to the extent that, you know, deputies' offense reports or incident reports might list someone who has a particular medical condition, you know, or list some medications. Maybe there were meds that were stolen. There's nothing that would exempt, you know, that medical condition or those prescriptions. Point being that if a record is going to be withheld or a record is going to be redacted, assuming that there is an exemption, you better find the statute to back it up, because in the reply to the public records request, you need to cite the statutory exemption. And so your public records custodian can't simply assume that something is exempt because it would appear that juvenile records are exempt, or it would appear that medical records are exempt. Look for the statute, and if there isn't a statute, then that's probably going to be a public record unless it doesn't meet the four-part test, which essentially goes, after we talk about all these essentially materials, to materials made or received pursuant to law or ordinance in connection with the transaction of the official business of the agency by an agency, and that would be including a private entity acting on behalf of a public agency, which are used to perpetuate, communicate, or formalize knowledge. And if we back up for a minute, you see how broad this public records law is, that public records include documents, papers, letters, maps, books, tapes, photographs, etc. So if you have these materials, then the question is, does it meet this four-part test as to whether or not it's a public record or not? And if it meets this four-part test, if that document is going to be redacted or withheld, again, it's got to meet a statutory exemption, and we better be able to find it in Florida statutes in order to withhold it, and we need to cite that specific statute in the reply to the public records request. What about physical evidence? Sometimes there's a request for, blood samples or something else that's physical in nature. And the answer to that, it's not a public record, and the reason for that, it's not susceptible to being copied, so it doesn't fall under the purview of the public records law. Okay, one of the other reasons that we need to know about the public records law is because, as you all know, there's a retention schedule. So to the extent that the Department of State has a schedule that for every record in your agency there is a time period to retain it, we need to abide by that particular schedule. It's a violation of the public records law if that document is not retained, if it's destroyed without complying with the particular schedule. And there are other consequences to it as well. In litigation, for example, that public record that may be otherwise an exhibit for the plaintiff, if we don't retain that record, then there's an inference that can be drawn against the sheriff's office that's given to the jury in an instruction if we don't hold it. So we need to know about the public records law, and we need to be able to identify what's a public record. And once we know that it's a public record, then we need to check the Department of State's retention schedule to determine how long it needs to be retained. And note that documents don't need to be retained in their original format. They can be stored electronically, and that's okay without violating the public records law. Something else I want to bring up too, and this is another one of these misconceptions about the public records law, and I want to bring this up in terms of your personnel file. You all get to decide what's in your personnel file. Say your human resources manager, for example, starts noticing that there are documents in the personnel file that really don't need to be there. Let's say you've got counseling memos, and perhaps the better place for the counseling memos would be with professional standards or internal affairs, so that we would know if there's, repetitive discipline if the issues keep recurring. So your human resources manager decides to remove those counseling memos and have them stored with professional standards. That is not a violation of the public records law because we're not destroying the record. The public records law doesn't dictate necessarily where the records need to be stored. It says essentially this is a public record, the public has a right of access to it, and the retention schedule determines how long you keep it. Okay. A couple of things we need to say with respect to email. First of all, in deciding whether or not email is a public record, it's all about the content. The medium doesn't matter. The computer doesn't matter. It really is all about the content. So if the content of the email fits the four-part test, well, it would be material. If it's made or received in connection with the transaction of the official business of the agency, and it's to perpetuate, communicate, or formalize knowledge, then if that email is sent on a personal computer, it's a public record. And on the other hand, if it doesn't meet that four-part test, it's personal in nature, and it's an email to the spouse, it's an email to friends, and it's on the agency computer. The fact that it's sent from the agency computer doesn't mean that it's a public record. So a couple of things that we want to gather from that. When you email on your personal computer and it relates to the business of the sheriff's office, you need a way to back that up. You need to make sure that you've retained that email so that it can be accessed. Most of y'all allow your employees, to use their personal computers, at least for limited purpose, for personal reasons, to email the spouse or family or whatever. And again, that doesn't translate into public records because it's personal in nature. We're going to take that concept and we're going to apply it elsewhere, like with regard to recordings of inmate phone calls, and get there in a bit. But again, it's all about the content. And does the content meet the four-part test? If so, it's a public record. If not, then it's not a public record and doesn't need to be produced. Okay. Text messages are just like emails. It's all about the content. So if you picture a text message in email format and the content would meet the four-part test, material, made or received in connection with the official business transaction of the official business of the agency, to perpetuate, communicate, or formalize knowledge, that text message is a public record. Now, we all know the problem with text messages, and that is not every agency has a backup system to retain text messages. And that's a problem if there's a public records request for text messages, and those are your text messages or they're text messages for a member of your agency, and they clearly relate to the business of the agency, whether it's an investigation and that investigation is closed. Obviously the investigative report's a public record. Well, what about the text messages that related to witnesses or the like? Well, if they're not around, that's a problem. So if you allow your members of the agency, your deputies, for example, to text message, then you either need to make sure you've got backup so that they can be retained, or if there isn't a backup system in place for that purpose, then it'd be a good idea to have a policy that limits any text messages to, basically transitory. That is, meet you for lunch, something along those lines that doesn't involve content that's a public record, to really limit their use. I know some sheriff's offices that have simply told their members of the agency don't text, because of the problems with public records requests and the text messages no longer being around. Your call, but keep in mind, a text message is no different from an email if the content meets the four-part test. So most of the sheriff's offices have Facebook, maybe all have Twitter, some of the other social media as well. Typically, what you post on Facebook would meet the four-part test for the public records law. So I would think that y'all have a way of retaining what's on your agency Facebook, and unlike the text messages, you've probably got something in place so that if something is on your Facebook page today, that's going to be retained in case it's ever requested somewhere down the line. So I'm confident that y'all have got something to handle that part of it. But many of you are on your own personal Facebook, you know, and so you want to think about that Facebook that you have, even though it's personal, as being subject to the public records law if you post messages that relate to the sheriff's office. Nothing changes. It's all about the content. If it meets the four-part test, it's a public record. So if you use your Facebook, your personal Facebook, for agency business, then make sure that you've got that backed up so that you can produce that if there's a records request. I don't need to get into this in great detail, but there are also First Amendment implications with regard to Facebook, that it's been deemed to be a forum for First Amendment purposes. So the other thing that you need to keep in mind too is, with respect to the Facebook that you've got, the agency Facebook, there ought to be a policy in place with regard to removing or blocking, and that's got public records implications, because if you follow your policy and somebody has posted something that's offensive or profane and that's removed, make sure you've got that backed up somewhere in case it's challenged, so you know you're able to produce it, because again, what you've got on your Facebook page, you know, constitutes public record. So you can remove it, but just make sure you capture it in case you need to produce it somewhere later down the line. Cell phone records, I think from my experience, there are two different types of records that are provided to your sheriff's office by the carrier, you know, Verizon, AT&T, or whoever it may be. Some of them will give for your cell phone, for example, the one that you have or the ones that members of the agency have, they'll have a statement, and all it does is just list a particular charge for that cell phone. You know, that's really helpful because you don't have phone numbers that are identified. But if it lists the cell phone numbers, that's the second kind that I've seen, so that you know, Verizon or AT&T gives you that monthly statement for you or the member of the agency, and it's not only got the amount, but it's got every number that's been called. It may be that those statements are public records. Certainly the first one that just indicates the amount, that's, you know, a public record because, you know, it's agency cell phone, so obviously the statement's going to be a public record. But what about the one that lists all the different phone numbers? Well, some of those phone numbers may be personal, and if some of them relate to something else that's confidential statutorily, you know, confidential informant, for example, you know, that would need to be redacted. So if there's a public records request for cell phone records, we start with the assumption that that record is a public record. But if phone numbers are identified, then somebody would have to go through that statement and redact the phone numbers that are personal or the phone numbers that are confidential. And really the only one who can do that would be you or the person who has that particular phone. And, you know, we'll get into special service charges next week, but if it takes time to do that, that time can be charged, and it would be the hourly rate of the member who has that particular phone, because nobody else can do it. So again, cell phone records are public records, but there may be a need to redact certain phone numbers that really wouldn't relate to the official business of the agency. Booking photos, generally, these are non-exempt, so they need to be disclosed. However, they might be part of an active criminal investigation, in which case, you know, they would be exempt. Once, of course, the investigation is done, then they'd be a public record, subject to disclosure, just like the investigative report. Juvenile booking photos, there was some legislation a couple of years ago that public records custodian has the discretion to publish booking photos of juveniles if they're charged with a felony or transferred to adult court. You know, that's consistent with what we know about juvenile arrest records. If juvenile is charged with a misdemeanor, then those arrest records are confidential. However, if the juvenile is charged with a felony, then the identity of the juvenile is protected. So the same thing with regard to the booking photos. If it's a felony offense, it's your call here with regard to whether or not you're going to give them up or not, because discretion is built in. So that's, again, something that you can decide, and it very well may be that with regard to some of these juveniles, those that are involved in committing serious felony offenses, or, your frequent flyers, that you would want to give them up. Officer booking photos, the short story here is if you have a written request from an officer who is arrested and charged with offense and booked into the jail, that written request for the booking photo not to be disclosed may be honored and should be, but I would make sure that you have a written request from the officer in case there's a public records request, so that you've got that to hang your hat on. I mentioned this earlier about inmate phone calls and how it still follows the discussion that we talked about earlier about the four-part test and what's personal and what's official. So if your four-part test is material made or received in connection with the transaction of the official business of an agency to perpetuate, communicate, or formalize knowledge, and you apply that to recordings of inmate phone calls, perhaps initially your first reaction is, well, if the jail records a phone call of an inmate, that's probably a public record. Well, actually it's not, and that's what the 4th District Court of Appeal decided in this Benton versus State case. And the reason they arrived at that particular conclusion was that it really did not relate to the official business of the agency to the extent of perpetuating, communicating, and formalizing knowledge, because it was personal in nature. So for that reason, if there is a public records request of recordings of inmates, then the response should be they are not public records, therefore they're not subject to disclosure under Chapter 119. If these recordings were part and parcel of an investigation, of a criminal investigation, once the criminal investigation is done, the recordings would be available because they're part of the investigative report. All right. I have thrown out the terms of confidential and exempt, so I want to spend a couple of minutes and clarify the distinction between confidential and exempt, because the distinction is very, very important in terms of withholding a record or having the discretion to give it up in some cases. So if a record is confidential, then there is no discretion to disclose that record unless, there are certain criteria that are met. And a very good example of that would be like medical records, for example, of your employees. And so there's a records request for some medical record of your employee. That's confidential. There's no way that you're going to give that up. But if the employee gave written consent for certain medical records to be disclosed, then okay, at that point, they could be released, but then and only then. We know with regard to juvenile offenders, that's confidential. Pre-employment psychological evaluations, that's confidential. That's not going to be disclosed. A really good example of this would be like if you had an officer who was Baker acted, having some really extraordinary stress, family situations, whatever. The deputy's Baker acted. Prosecutors got several cases by that deputy, and here's that your deputy's been Baker acted and says, I'd like to see that psychological report because I want to know whether or not I can trust, this deputy and I just need to know what I'm dealing with. That's not going to happen. That's a medical report. That's not going to happen. Maybe public knowledge that the deputy was Baker acted, but that prosecutor is not going to get that report. If you did fitness for duty on that deputy before the deputy came back by your agency psychologist, that prosecutor is not going to get that psychological. That's a medical record. That is not going to happen. Exempt records may be disclosed, but you're not required to give them up. Again, you've got the discretion to do that. That would be with regard to your ongoing investigations. Home addresses, phone numbers of your personnel, security system plan, maybe like jail video with regard to whether you wanted to give it up or not, whether you deemed that video in the jail met the security system exemption, or whether it was video of a hallway and you felt like it really didn't compromise security of the jail. Your call on whether you want to give that up or not. All right, we all know about active criminal investigations. I've referenced it several times this morning, and no surprise that if there's an ongoing criminal investigation, then it's exempt from disclosure. So this is how criminal investigative information is defined. Information with respect to an identifiable person or group of persons compiled by a criminal justice agency in the course of conducting the criminal investigation of a specific act or omission, including but not limited to, and lab tests, reports, and surveillance, etc. What's active? Well, by statute, it's got to relate to an ongoing investigation. There's got to be a reasonable good faith anticipation of securing arrest or prosecution in the foreseeable future. And if it would constitute active criminal investigation, but it's turned over pursuant to discovery by the assistant state attorney, you can't assert the public records exemption as an active criminal investigation. So it's probably a good idea if you've turned information over, your reports or with the state attorney, and there's an ongoing investigation and there's a public records request for the criminal investigative report, before you give that up, I think beneficial for your public records custodian to call the prosecutor that's assigned to the case and say, I've got a public records request for our investigative report. Where are you on this? Is there any problem with giving this up? Normally arrest reports are public records once they're done, even though the state attorney's got the case. So you can call the state attorney, about a criminal investigative report and whether or not there's still an ongoing investigation by the state attorney, which means that they don't want you to give that up. So state attorney is helpful in deciding whether there's an ongoing investigation, but do not depend on the state attorney to make calls on what's a public record or not, because, you probably know the public records law much better than they do, and if they're wrong, you're on the hook, not the state attorney's office. So the state attorney's office needs to be contacted if there are questions about whether there's an ongoing investigation, and these records that have been requested are part and parcel of that investigation. But that's all I would rely upon the state attorney's office for. I certainly wouldn't put them in the position of determining whether or not to comply with public records requests otherwise. Active criminal investigation, this is pretty much like with the investigative information, except that it's broader in nature and relates to a gang. So again, as long as there's an ongoing investigation, reasonable good faith belief that it's going to lead to arrest or prosecution, then that can be withheld. I bring this up when I talk about public records law because we cannot assume that because there's an ongoing criminal investigation that everything relating to that investigation would be exempt. And this Barfield versus City of Tallahassee case is a very good example of why there is just no broad exemption applicable with regard to the ongoing investigation, because in this case, the First District Court of Appeal correctly applied Public Records Law 119011, subsection 3, paragraph C, to the effect that the time, the date, the location, and the nature of the reported crime and the crime charge are excluded from that exemption. Barfield case is a very good example of why we don't have a broad sweeping exemption, and you have to be particularly careful of those records that relate to the investigation and when there's a request for those records. Here in Barfield, there was a request for the email of a Facebook post at the Tallahassee Police Department. It was regarding a domestic violence incident relating to an athlete at FSU. And so the public records request was, for that Facebook post that had been sent over to the Tallahassee Police Department. And Tallahassee Police Department took the position that there's an ongoing criminal investigation, you don't get it. And that was challenged, and the District Court of Appeal said the police department was wrong because while you can redact the narrative, that part of the Facebook post, to the extent that it had identified the time, the date, location, the nature of the alleged domestic violence, would be unredacted, and therefore you could give up the post and redact everything other than what related time, date, location, and nature of the offense. So your public records custodian needs to keep that in mind if there are records requests for documents relating to an ongoing investigation. We've done this in the past, and I've assisted some of your records custodians when there's been a request of that nature, and we've taken a complaint or an offense report, and because there was an ongoing investigation, we have given up the document and redacted the narrative, but left intact that part of the report that identified the nature of the offense, say, it was a robbery, the date that it was supposed to have occurred, where it was supposed to have occurred, and everything else with regard to the ongoing investigation was redacted. So the individual who made the public records request didn't get much, but they got something. Okay, we're going to talk about administrative investigations, a couple of other matters on what's public record and what's not. Most of you all know that ongoing investigations, internal investigations with regard to your sworn of the Bill of Rights are exempt until such time as you've made the decision with regard to discipline. I think that the point at which we know whether or not an internal investigation is a public record or not is if there have been sustained policy violations and there is a pre-disciplinary conference. Only after there's been a pre-disciplinary conference would the investigation be final, the discipline be determined, and the internal investigative report be a public record. Because prior to the pre-discipline conference, everything, in my opinion, is still an ongoing investigation, because there may be something brought up at the pre-discipline conference that reflects on the investigation. Somebody else needs to be interviewed, for example. So if the complainant asks for the internal when it's done, but there has not been a pre-disciplinary conference, then the response to the complainant is it's still an ongoing investigation. Once the pre-disciplinary conference has been held and you or your chief deputies made the call on whether there's going to be discipline or not, at that point, it can be given up. Also want to bring up, too, if there's a career service appeals board and it's been requested, I don't think that changes the character of the investigation. Once you've had the pre-disciplinary conference and you've decided on the discipline, the fact that there has been a request for an appeals board doesn't mean that now it's still an ongoing investigation. I think at that point it's open to disclosure, and the investigative report would be a public record. Okay. Also, I did mention the Bill of Rights, but note the statute that says that investigations against employees, including civilians, are confidential pending conclusion. That does not mean the Bill of Rights apply to your civilians, but it does mean that you treat the ongoing investigation as being exempt until such time as it's done. And all right. This is a Bill of Rights provision, and I threw this in there because you should know that under the Bill of Rights, even though that this is confidential and exempt, you can acknowledge the existence of a complaint and an ongoing investigation. Your call on how much you want to give up, probably less the better, but if there's an internal investigation with regard to use of force on some of the detention deputies, they've been put on administrative leave with pay. If there's been a request by the media without violating the Bill of Rights, you could say, yes, we have ongoing investigations with regard to these deputies. They've been placed on leave pending the outcome of the investigation, and you're done. Okay. Last thing I want to talk about before we talk about some fact situations. Most of y'all understand the process with the Equal Employment Opportunity Commission, Florida Commission on Human Relations. You know, those of y'all that are in the fund, our firm handles those for the fund, and when there's a charge of discrimination to Florida Commission on Human Relations or the Equal Employment Opportunities Commission, we draft a position statement for your sheriff's office for the Florida Commission on Human Relations. FCHR actually does an investigation, and ultimately there's something in writing that discloses whether or not they think there's cause or no cause. EEOC, you really don't get anything until a long time has passed, and then they'll basically do a one-page that's a dismissal and notice of rights. Keep in mind that if there's a public records request for the FCHR charge or EEOC charge, you don't give that up until such time as EEOC or FCHR has ultimately determined, based upon the investigation, whether or not there's cause or no cause. So in the case of FCHR, when they issue the report from the director that in most of our cases, fortunately, it's been no cause and indicates, you know, they can go to the Division of Administrative Hearings. That point, it becomes a public record. When EEOC issues its dismissal and notice of rights, at that point, it'd be a public record. Charge would be open for disclosure. Okay, I've got a few of these fact scenarios that pull together what we've talked about this morning, so let's do the first one. So I prepared this one because it's similar to what was happening a couple of years ago when a couple of individuals who basically made a living out of testing agencies on complying with the public records law, and were going around seeing if they could get a public records violation and then suing the agency for it, sheriff's offices included. And this is a tactic that was often employed. Someone would walk into the jail lobby and ask to inspect the visitor logs, you know, for the past week. So a number of sheriff's offices will keep these electronically, and they'll be held in a secure area of the jail. And let's assume for this scenario that your receptionist says, one, I need to see some identification before we can ever give you anything, and he declines to give identification. So question here is, are those visitor logs public records? Can we deny giving them the records because they're stored electronically and they're in a computer in the secure area of the jail, and can we require identification? And the answer to those two questions are the visitor logs are public records, and the better way to do this would be to print them. We don't have to give them access to the secure area of the jail. Print the logs and make them available, and we cannot require this individual to identify himself to produce a driver's license. That's not a requirement of the Public Records Law, and hopefully your folks have been instructed along those lines, because if they're asking for identification and somebody refuses to give it and is denied a public records, that's a violation of the Public Records Law. And I also want to bring this up. I think most of y'all have done it, but you probably know that maybe about a year or so ago, the Public Records Law was amended to provide that if you post the contact information for your public records custodian in the lobby and you put it on the website, then prior to a public records lawsuit, the agency's got to get 5 days notice. So make sure that y'all have got a notice in your lobby, and you've also got it on the website that provides for phone number, email contact for the public records custodian, so that we comply with this and we get the benefit of 5 days notice before there's a lawsuit. You know, public records lawsuits are expensive. The fund doesn't cover them, and so it's on your dime. So, you know, the more you can do to put yourself in a position to correct any public records violations, the better. Second scenario, a member of the public sends an anonymous email requesting salary records of the command staff. So what about it? Are salary records public records? And the answer to that is yes, they are. If we have records that detail the salaries, then they are records that are open for inspection. Now, nothing in the Public Records Law requires you to create a record. So if in responding to this public records request, all you've got are salary records for each individual member of the command staff, you don't have to create a record now. One document lists all those salaries. You don't have to do that. You can say, you know, maybe you're a large agency and you got, you know, 10 that are part of the command staff, maybe more. You can tell them we have these records, you know, maybe they're payroll records, you know, they're available for inspection. Maybe the easier thing is to create a record. That's up to you rather than them reviewing individual pay records. How you want to handle that is up to you. But the point being, there's nothing exempt or confidential about payroll records. Obviously, Social Security numbers would be redacted. Any home addresses would be redacted. But something that just lists salary, that's a public record. It meets the 4-part test. So there's no exemption, and that would be subject to disclosure. If it required a good bit of time to go through and get that information, you know, make those records available, to redact them and the like, then special service charge may be applicable. Third scenario, so this goes back to creating the record issue. So there's a public records request, and it wants records of arrests of minorities in the past 12 months and gender, race, and age. So what about this? Do we have to create a record now that summarizes this arrest information for the benefit of the person making the request? And the answer is no, but there would be obviously arrest reports in the past 12 months, and a couple of ways to go about doing that. Tell them we can make these arrest reports available, but if we're going to go back 12 months, that's going to require an extensive amount of employee time. Here's how many hours we think it will require. Here's the hourly rate for that particular individual, and it's going to cost in the neighborhood of, say, $400, $450, whatever. And we're going to need that up front before we do it. We can require that, you know. We don't have to create a single record. There have been requests like this, you know, some of these criminal justice agencies, these, you know, outfits that, you know, are looking for issues with law enforcement agencies, and they've been making these requests. Some of them have got the money to do it. You may get it from the media. They may have the money to do it. But we don't have to summarize, collate that in one single document if a document does not exist. Fourth scenario, okay, so they want your calendar. It's kept by your executive assistant. So what about it? Is that a public record or not? Yeah, it's going to be a public record. Now, there may be some personal information in there that relates to you and your family that has nothing to do with the business of the sheriff's office. And so at this point in time, I would say that that's a public record that needs to be disclosed. There's a case to watch, and it involves the governor, and requests were made for the governor's calendars. The governor's staff declined to give up the calendar, saying that it compromised his security, and they invoked, the security exemption under the public records law. That went before a circuit court judge here in Tallahassee. A circuit court judge said, no, that's not a security issue, sorry. It doesn't fall under that particular exemption. And so that's up before the First District Court of Appeal. My prediction is the First District Court of Appeal is going to affirm that order, which is why I think that if there's a request for your calendar, that's a public record. So that's all I know about that. All right, the fifth and the last one for today. Here's a criminal investigation of a school official for embezzling funds. So there's been an anonymous written complaint, and the paper requests a copy of the complaint. So this goes back to the Barfield case we talked about earlier. Again, based upon that Barfield case and the specific statutory definition of an active criminal investigation, we would need to provide the complaint and redact everything other than the date, location, nature of the crime, and the crime charge. So they may not get much. They'll get the complaint, and most of it may be redacted, but you need to give the complaint, if it's apparent from the complaint, the date of the embezzlement. Obviously, it's going to have something in there with regard to, embezzling funds, so, we wouldn't redact that, where it occurred, so it's, the school, and that's going to be left intact, crime charged, again, embezzlement. So there may be a dozen words or so that are unredacted, and the rest of it is blacked out, but that's what we would give to the media based upon the public records request. And that's where we're going to stop today. Next week, we're really going to spend a lot of time on exemptions and also complying with the public records request in terms of what you can charge, how you determine the charge, and the like. And so I'll take questions with what we've covered today.
Do we have any questions?
Wayne, Sheriff Lanier from Hardy County. How you doing?
Good. How are you?
Good. Question back on the EEOC discrimination. Have you heard anything on the access to web pages, the PDF files? They say they're discriminating if they can't pull those up, and we're going to have to change our format.
I'm not sure what you're talking about. Tell me what you mean. I'm not sure I get it.
I believe something's come up on accessing Sheriff's Office or Police Department's web page that a PDF file or something of that nature, I better get clarification on that is discriminating, and a lot of them having to shut it down until they get in compliance with those. So let me do some research on it and get back with you to clarify, and I'll call you on it.
Yeah, that'd be great, and then I can share it next week because I'm not familiar with it. So, let me know, and we'll be glad to look at it. And again, if there's something to it, I'll talk about it next week.
Okay, thanks.
Sounds good.
Wayne, Bob Johnson from Santa Rosa.
Hey, Bob.
Hey. In reference to text messages, if somebody, let's say somebody requests all my text messages off my work phone, and I have to determine myself who, which ones are I can redact and which ones I can't. So I just basically, however long that takes me for whatever period they asked, how far back, I can charge them my salary for that?
That's exactly right. And what you should do, if it's, let's say it's for a couple of months, at the outset, I would estimate how long you think it's going to take you to go through all these text messages. You probably have a million of them. So you could give them a general estimate and use your hourly rate because nobody else can do that, only you can do it. And that may narrow the time frame substantially, you know, particularly if it's going to be your hourly rate and it's going to take you 4 hours or 5 hours, you know, to do it. If that's reasonable, you know, I would give them that response before you ever start doing it and tell them that, you know, you're going to require a deposit up front.
Right. Okay.
That's
Thank you.
your rate. Yep.
Anyone else? Okay. So I guess that concludes our webinar today. We'll have another one next week.
All right, thank you. I'll talk to you next week.